Right, good morning.
Good morning.
For the record, Sherra, S-H-E-R-R-A, last name Wright, W-R-I-G-H-T. Docket number is 1705881. Ms. Wright is present. Mrs. Julie Ganguly, Ms. Lori Hall are present for Ms. Wright. Ms. Paul Hagerman, Mr. Austin Schofield are present for the state of Tennessee. This case is currently set for trial on September 16. (2019). And the lawyers asked the court to advance the case today for today's docket, indicating that there's a possibility that a resolution has been reached in lieu of trial. Is that correct, Mr. Hagerman, Mr. Schofield, Ms. Ganguly, and Ms. Hall?
Yes, sir.
Ms. Hagerman, you may proceed to the announcement, please, sir.
Yes, Your Honor, we're here for a guilty plea in the matter. And I'll say first, there's a large amount of family and friends of the victim, Mr. Wright, here, and they're in full support of this guilty plea.
Yes, sir.
This is 17-05881, State of Tennessee versus Sherra Wright. She's represented by her attorneys to include Mr. Ganguly and Ms. Hall. On count one of the indictment, Sherra Wright will enter a plea of guilty to the offense of facilitation to commit murder in the first degree. That is a Class A felony. Ms. Wright is a Range 1 offender. However, she will plead guilty as a Range 2 offender with regard to the sentence length of 30 years. She will have the release eligibility of a Range 1 offender at 30%. She'll also be pleading under count 3 of the indictment. She'll be pleading guilty to facilitation to commit the offense of criminal attempt, murder in the first degree, 8 years confinement as a Range 1 same offender. The 8 years will run concurrent with the 30 years announced on count 1 of the indictment. Upon pleas to count 1 and 2, count 1 and 3, count 2 of the indictment, which is a conspiracy count, will be nullified without cost.
Yes, sir.
Had these matters gone to trial, the state's proof would have been that on July 19th of 2010, just after midnight, in Germantown Police Department, on one call, it was a hang-up call in which a male voice can be heard, and then numerous gunshots. Lorenzen Wright was reported missing by his mother 2 or 3 days later. His last known location was a house at 4530 Whispering Woods with his then ex-wife, Sherra Wright. That's in Collierville, Tennessee. After officers located that 911 call and there was a delay doing that, officers were dispatched to search for the body of Mr. Wright, and they found Mr. Wright's body had been there for some time, about 9 days, in a field in Memphis, Tennessee, off Calais Cutoff, just west of Hacks Cross. Around the body of Mr. Wright, officers located several 9mm shell casings that were collected and would later figure as evidence in the case. Sometime thereafter, an individual by the name of Jimmy Martin, who identified himself as a co-conspirator of Mr. Turner and Ms. Wright, gave a statement to police officers in which he said that he was present for two meetings with Ms. Wright and Mr. Billy Turner, in which the murder of Lorenzen Wright was planned. He also stated that he helped those individuals clean up some of the crime scene, and ultimately traveled with Mr. Billy Turner to dispose of the murder weapon, which was later found in a lake not terribly far from Memphis. Officers recovered that firearm and it was sent to TBI, compared against the casings located around Mr. Wright's body, and it was determined to in fact be the murder weapon. There would be other evidence presented in the case that would corroborate the account of Mr. Martin, other corroborating evidence with regard to the statement that he provided law enforcement. Also in his statement to law enforcement, he stated that there was a prior attempt to kill Mr. Lorenzen Wright, and that's why he was in Atlanta, Georgia. He stated that he went to Atlanta, Georgia with Billy Turner, that they entered the home of Mr. Wright, and Mr. Wright wasn't there, but they did so at the direction of Ms. Wright, who had participated in that plot as well. Officers also interviewed several witnesses in the case, to include Claudia Robinson, who stated that she had been present when Ms. Sherra Wright, Jimmy Martin, and Billy Turner had discussed the murder of Lorenzen Wright. They also interviewed various individuals who would testify as to incriminating statements or actions that Ms. Wright took in the days after Mr. Wright went missing. Later in 2017, officers disclosed to the media that the firearm had in fact been found. It was a murder weapon in Mr. Wright's homicide. They obtained a court-ordered wiretap on a phone belonging to Ms. Wright. Pursuant to that wiretap, officers recovered several incriminating statements and other incriminating evidence from the cellular telephone after it was released to media that the gun had in fact been found. We'd ask counsel to stipulate to the facts, Your Honor, to accept negotiated pleas.
Ms. Wright.
Ms. Wright.
The facts are stipulated. We would ask the court to accept the negotiated plea agreement.
Yes, sir. Ms. Sherra Wright, come forward, please, ma'am.
Stand here.
Try to come into the circle right here, Shelby County, Tennessee, and raise your right hand, please, ma'am. Do you solemnly swear or affirm the testimony you will give this call to the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Ms. Wright, thank you. Now, and I'll have a seat right here, please, ma'am. Watch your step, please. Ms. Wright, good morning. What's your real name?
Sherra Wright.
Ms. Wright, how much education do you have, ma'am?
In excess of high school or 3.5 years of college?
Now, this would sound like a really silly, ridiculous question, but can you read and write it for Ms. Wright?
Yes.
Ms. Wright, I'm going to show you a document for the record. This is a petition for waiver of trial by jury and a request for acceptance of a plea of guilty. Do you recognize this form, ma'am?
Yes,
On the bottom right-hand corner where reads defendant, did you sign that?
I did.
Ms. Wright, all of your state and federal constitutional rights above your signature, Mr. Ganguli has circled and underlined some of those rights that he and Ms. Hall those rights with you and explaining to you, ma'am.
Yes,
Ms. Wright, do you understand the rights that you're waiving and giving up today, ma'am?
I do.
Ms. Wright, you have an absolute right to have a trial in your case. You understand that?
I do.
Your case is set for trial on September 16. You have an absolute right to have a trial in this case. You understand that?
I do.
Ms. Wright, when you entered this guilty plea today, you heard Mr. Paul Hagman read some statements in the court a few minutes ago. And when you plead guilty, when you enter this change of plea, you're telling the court that if you had a trial in your case, had you gone forward with this trial, the state of Tennessee would bring witnesses to court. They would testify consistently with those statements that were read in court today. You're telling the court, Ms. Wright, that if the jury believed the state's witnesses, that jury would have enough reason to find you guilty for the offenses that you're pleading guilty to. You understand that, ma'am?
Yes.
Now, had you gone to trial with Sherra Wright, you would have the right to confront and cross-examine all those witnesses against you. Ms. Hager, Ms. Schofield, have to bring those folks to court. You can look at them in person, face to face. They would sit right there in that chair on the witness stand where you're presently seated, and your lawyers requested them to see if they're telling the truth. If a jury did not believe the state's witnesses, did not believe the state's proof, Ms. Wright, that jury would find you not guilty, and I would dismiss this case against you. Do you understand that now?
I do.
Had you gone to trial on this case, you would also have the right to present proof, to put on evidence, to call witnesses if you wanted to. Ms. Wright, you would never, ever have to do anything at a trial. You can take the witness stand. You can tell the jury what happened. You can tell the jury your side of this story if you chose to do so. If you made a decision to remain silent and not say one single word, I would tell that jury not hold it against you for any reason at all. You understand that now?
Yes.
Had you gone to trial in this case, if you had any witnesses that could help you, Mr. Gangul and Ms. Hall would send them a subpoena, but have them come to court and testify for you. If they didn't show up, or they just flat out refused to come to court, I would have the sheriff locate those folks, Ms. Wright. I would have those folks arrested. I would make them come in. I would make them testify for you. If I had to, I would put those folks in jail until your case was tried. Do you understand that, ma'am?
Thank you. Yes, I do.
Now, had you gone to trial in this case, and had a jury found you guilty of anything, you can appeal any conviction the jury gave you. You can appeal any punishment that I gave you. the Court of Criminal Appeals will grant you a new trial or even dismiss your case if that court found mistakes have been made in your trial. If you cannot afford a lawyer, Ms. Wright, I would appoint someone for you free of charge to handle that appeal. Do you understand that, ma'am?
Yes, sir.
When you enter this change of plea, when you enter this guilty plea today, you're giving those rights up. You're waiving those rights. You are asking this court to find you guilty without a trial and to set this punishment which has been recommended on your case. Now, is that what you want to do, Ms. Wright?
That is correct.
Has anyone threatened you, promised anything, put any force, any pressure on you in order to get you to give up these rights and plead guilty?
No.
Ms. Wright, you have a 3-count indictment, 170581, charged you with first-degree murder. It carried 3 possible punishments. State had not filed a notice to seek an enhanced punishment against you. So if you went to trial in this case, the death penalty of life without the possibility of parole would not have been an option. But had you been convicted of first-degree murder, the court would have to sentence you to life imprisonment. And life under the current Tennessee law is considered to be 60 calendar years. You have to serve 51 calendar years before you became eligible for release. You were also charged with conspiracy to commit a felony in counts 2 and 3, conspiracy to commit a first-degree murder. And that is an A felony, Ms. Wright, that carried anywhere from 15 to 60 years in prison. Now, do you understand the full punishment you could have received had you gone to trial and had you been convicted by a jury, Ms. Wright?
That's what I'm getting.
Ms. Wright, the agreement that you have to state is that you would plead guilty to the included charge in count 1 to facilitation of first-degree murder. That Class A felony carries anywhere from 15 to 60 years in prison, fines up to $50,000. You pleaded guilty to count 3, facilitation to commit a felony, to wit, criminal attempt first-degree murder, and that B felony carries 8 to 30 years in prison, fines up to $25,000. This right to agreement that you have stated that you served 30 years confinement in the Tennessee Department of Correction for the facilitation of first-degree murder, a 30-year sentence as a range 1 offender, 30% release eligibility, 8 years confinement in the Department of Correction for facilitation of a criminal attempt first-degree murder. Those 2 sentences running together or concurrently, Ms. Wright, makes this one effective sentence of 30 years at a 30% release eligibility. Now, is that the agreement that you have to state in Tennessee, Ms. Wright?
Yes, sir.
Ms. Wright, this is what is referred to as a hybrid guilty plea. Hybrid guilty plea, meaning that you're pleading guilty to a range 2 sentence of 30 years. What those agreements told the court is that you're a range 1 offender. In order to be sentenced to 30 years, you would normally have to have at least 2 prior felony convictions. You are not a range 2 offender, Ms. Wright. You are in fact a range 1 offender, but you're pleading guilty to a range 2 sentence of 30 years, but with a release eligibility as a range 1 offender of 30%. It's a hybrid guilty plea. As long as you enter in that guilty plea intelligently and knowingly, Ms. Wright, you can plead to a range 2 sentence and combine that with a range 1 release eligibility. You understand that now?
Yes, sir.
And the second count of this indictment will be null prosecuted, dismissed without cause. Ms. Wright, these are 2 felony convictions. They are permanent. They would be on your record forever. If you're convicted of other crimes, it could be used enhanced punishment against you by making your range 2, a range 3, a career, or repeat violent offender. The more felonies you have on your record, the more punishment you get. You understand that now?
I do.
Ms. Wright, facilitation of first-degree murder is a violent offense under Tennessee law. If you're convicted of other violent offenses, that conviction could be used to make you a repeat violent offender. You can be sentenced to life imprisonment without the possibility of parole. Do you understand that now?
Yes, sir.
Facilitation of first-degree murder, facilitation of an attempted first-degree murder, also felonies whose statutory elements involve violence to a person. And what that means, Ms. Wright, God forbid, if you're ever convicted of any form of first-degree murder, these 2 convictions could be used to get you the death penalty or to get you life imprisonment without the possibility of parole. Do you understand that now?
Yes, sir.
Ms. Wright, as a result of these felony convictions, I am required to render you infamous. You lost all of your rights of citizenship. For instance, you lost the right to vote. You can't vote until that right is restored or given back to you by a judge in circuit court or by a petition from the Tennessee Department of Correction. You understand that, Ms. Wright?
Is that the only right that I've got?
No, ma'am. You've also, for the rest of your life, you can never serve on a jury. You can never possess. You can never carry, you can never buy, you can never own any handguns, firearms, rifles, shotguns, pistols, ammunition, or even bullets. Ms. Wright, if you have in your hands, in a car, in a house, in your purse, any firearms, even one single bullet, the United States government prosecutes you in federal court for being a convicted felon in possession of that firearm. You can go to federal prison for a long time. If you possess any handgun or firearm, Tennessee can prosecute you for that. That carries up to 30 years in state prison. You understand that now?
Thank you, Your Honor. Yes, I do.
Ms. Wright, you have been sworn to tell the truth. Everything that you say under oath while you're seated in that chair on the witness stand has to be true. If you don't tell the truth, Ms. Wright, to say could indict you for perjury, that carries up to 12 years in prison. Do you understand that now?
Yes.
Do you have any questions about the rights that you waived, the guilty plea you entered, or the agreement you have to state in Tennessee, Ms. Wright?
None at all.
Ms. Wright, had you gone to trial in this case, one other thing I need to mention, had you gone to trial in September, in addition to charging first-degree murder, which I told you the state was not seeking an enhanced punishment, although if you're convicted of first-degree murder, I would have to sentence you to life imprisonment. But I would also charge the jury on what's called included offenses, including second-degree murder, which carries 15 to 60 years in prison. That's a violent offense also. You have to serve 100% of that sentence if you were convicted of second-degree murder. The jury would also be charged on what's called voluntary manslaughter. Second-degree murder is a knowing killing of another person, an intentional knowing killing of another person. Voluntary manslaughter is a intentional knowing killing of another person done in the heat of passion produced by adequate provocation that would cause a rational person to act in an irrational, unreasonable manner. Adequate provocation from the alleged victim. Aggravated or voluntary manslaughter carries 3 to 15 years in prison. Criminal reckless homicide, rather, is a reckless killing of another person that carries 2 to 12 years in prison. And criminal negligent homicide is an E felon which carries to 6 years in prison. The jury would have been charged on those lesser offenses had this case gone to trial. Do you understand that?
Yes, sir.
You have any questions about any of these steps, Ms. Wright?
No, thank you.
Ms. Wright, I know at one point we had some doctors look at you to make sure that you were competent, to make sure you understood these charges and that you could help your attorney, and those doctors told me that you were fine. Now, are you taking any medications today?
I am.
And what medications are you taking, Ms. Wright?
There's one, Lexapro,
Yes, ma'am.
and it's for anxiety and depression. And then the other is Vistaril. It's more like it's equivalent to Benadryl.
Yes, ma'am. Now, do you have any questions about anything that I've talked to you about today, and anything Ms. Gangle and Ms. Hall might have talked to you about?
No, sir, you've been thorough. Thank you.
Do you have any complaints about anything that Mr. Gangle has done since he's been your lawyer, Ms. Wright?
No, Ganguli has been thank you. He's been excellent, him and Ms. Hall.
And the reason I asked you that, Ms. Wright, because this is July the 25th, 2019. Ms. Wright, in September, I would have been a judge for 13 years. Seems like it's just yesterday. And I hear guilty pleas every day, every week, every month. People will plead guilty and tell me just cause I'm happy with my lawyers, have no complaints about my lawyer. And a week from now, a month from now, a year from now, they'll start filing petitions that say, Judge Coffey, I really wanted a trial. I did not want to enter a guilty plea. The only reason I pled guilty is because Mr. Gangle and Ms. Hall made me do it, or they talked me into this, or I just didn't feel comfortable with my lawyers. If you have any complaints at all about anything that Ms. Hall and Mr. Gangle has done since they have been representing you, now's the time for you to let me know that. Do you understand that?
Yes, sir.
Do you have any complaints about your lawyer, Ms. Wright?
They are wonderful. They've been wonderful.
Yes, ma'am. Mr. Gangle and Ms. Hall, you have any questions of Ms. Sherra Wright?
No, thank you, Judge.
Ms. Sherra Wright, I'm going to find that Mr. Junie Gangle and Ms. Lori Hall have represented you satisfactorily. I find Ms. Gangle and Ms. Hall and this court have explained all your rights to you. I find that you understand those rights and that you have waived it, you've given up those rights intelligently and knowingly. I do find, Ms. Wright, that there is a factual basis. There is a reason for this change of plea, which has been entered freely and voluntarily. Upon your plea of guilty to indictment 17-05881, count 1, facilitation of first-degree murder, class A felony, as included in this indictment. Ms. Wright, it is the judgment of this court that you are guilty. This court sets your punishment at 30 years confinement in the Tennessee Department of Corrections as a standard range 1 offender. And again, this is a hybrid guilty plea pursuant to Hoover, H-O-O-V-E-R, and Mailer, M-A-H-L-E-R, in which you are pleading guilty to a range 2 sentence that is combined with a range 1 release eligibility. count 2 is dismissed. And upon you plead guilty to count 3 of the indictment, facilitation of a felony to win criminal attempt first-degree murder, a Class B felony, as included in the indictment, is right in this judgment of this court that you are guilty. And the court sets your punishment at 8 years confinement in the Tennessee Department of Correction for women. These 2 convictions are running concurrently, making this one effective sentence of 30 years at a 30% release eligibility. It's right on paper. 30 years at 30% is 9 years that you have to serve before you become eligible for release. Now, this release eligibility date is not set in stone. It could be less than that, it could be more than that. It depends on your credits, your programs, your behavior. But this is a 30-year sentence at 30% of which you become eligible for release after serving 30% of that sentence, which is 9 years on paper. You understand that now?
Yes, sir.
The court does ready the infamous. You lost all of your rights and citizenship. Not signed an order that would allow you to pay your court costs once you are released from custody, Ms. Wright. Do you have any questions or anything to say before this judgment is entered, Ms. Wright?
No, sir, but I do get credit for the time I've already spent. That's right.
Yes, ma'am. How long have you been in jail? It's over 2 years now. Over
Not
a year?
quite. Mr. Turner came before I did.
Yes,
So
ma'am.
21 months.
You've been in jail 500 days because I think you remember this is folks that have been in this jail for 500 days. Is that
Yes,
correct?
sir.
You get credit for every day you've been in jail towards this sentence, Ms. Wright.
Thank you.
Any other questions, anything to say before the judgment is entered?
None at all. Thank you.
Ms. Wright, thank you, ma'am. It's been, you've been very pleasant every time you've been in this court. Thank you, ma'am. Ms. Sherra Wright, I'm going to order that this judgment and must be entered and executed on your case with order the sheriff to transfer to the Tennessee Department of Correction for women for the house until you serve a balance of this 30-year sentence, Ms. Wright, and you get credit for every day you've been in jail towards this sentence. Ms. Wright, Ms. Step down for witness stand up. What you would like, ma'am?
Thank you.
Thank you, ma'am. Miss Deborah Marion. Ms. Marion, good morning. Ms. Marion, when you were first in court, you had some things that you wanted to say.
Yes.
And I told you that it was not an appropriate time at that time.
Right.
But I did tell you at the conclusion of this case, whether it is by a trial or guilty plea or whatever the conclusion was, I told you I would allow you to say anything that you wanted to because you have a right under Tennessee Crime Victims Bill of Rights. You have a right to express those sentiments to the court. You understand that?
Yes, sir.
I do appreciate your patience. I know this has been going on for, what's been 9 years now? And I know you've gone through a lot. I know your family's gone through a lot.
Thank you, sir.
I know it's putting you through a lot of pain. And I know that you have endured a lot to bring this case to this point. And it took 7 years to get somebody charged with this conduct for the killing of your son, Lorenzen. And I know it has been very difficult for you and your family. And you did what the court asked you to do. I told you, Ms. Marion, this is not the right time. When Ms. Sherra Wright was first in court, and I asked you to please be patient and to please be civil and not have any outbursts because I wanted you to be present every time this case was set. And I will allow you to vocalize or verbalize anything that you want right now, Ms. Marion, because you have that right under our Constitution, ma'am. Thank you, ma'am.
Thank you, sir. But Sharon, I want to thank you for giving me my grandchildren. That's what I want to thank you for. But I want you to unlock them so I can visit them, so they can see their grandma. Because Sophia keep calling, she wants to come make chicken and dumplings. She wants to come to Memphis just to make chicken and dumplings, and I want her to come. And the twins going to be playing basketball near us now, so we want to see them too. We want them to be talking, let them know we didn't do anything to them. We didn't lie to them or anything. We just love them. We just want to see them. That's all. I want you to get the kids and let them know we didn't do anything to them. We love them. We want to see them. You know, Trail, they're the same. You know, Trail is the same. You know how they be triplets for like, what, 3 months? That Trail is the same age. He misses his nephews. And Trail finna be 20, and they're not gonna see him be here at 20. But I want you to call them. No, it's okay to talk to your grandma. Grandma still loves you. That's all I want my grandkids. That's it. I just hate what happened to my child. But he left some nice looking kids here for his grandma. For they want to see me like I want to see them. Lamar wants to see me. Sophia want to be dressed. Dumplings. You know how I let her cut them out with a piece of color. And she want to do that. And I'm ready for them to come back to home with their family. That's I miss them.
Am I able to respond to her?
Mr. Gainville, you want your client to say anything at this point, sir?
No, Miss Wright has nothing to say at this time.
Ms. Marion, again, I want to thank you.
All right, thank you,
Your
Judge
family,
Carter.
want to thank you for your patience, want to thank you for allowing the legal process to run its course, Ms. Varian. And I hope, and I know what has happened to you and your family, your son, can never be undone by anything that these courts do. But I hope it brings you some closure. And I hope it allows your family to continue to heal. And again, thank you for your patience, and we'll deal with Mr. Turner's case in September, ma'am. Thank you all for being in court today.
Thank you, Judge Carter.
On this time, we call for the recess and work remains.
Court stands in recess.
Yeah, I record when you finish your task.